And now this very 10th schedule is actually subverting that. In the meantime, politics takes over. You topple the government. Saying, Millers, that both the law and those who interpret the law was hoping, Millers, that this would serve the cause of justice. But what's happened over the years, Millers, that the politician is far more artful. And Millers, in fact, the working of the 10th schedule, and in this context, has actually served the cause of political immorality. And this is a quintessential case of what that political immorality is all about. Now, Millers, as far as Naban Rabia is concerned, let me just briefly tell you what the submission is going to be, and then I'll go into the details. Millers, Naban Rabia says that when a notice is issued to the speaker seeking his removal, the moment that notice is issued, Millers, he cannot act as a tribunal under the 10th schedule. As your Lordship knows, Millers, that sessions take place, one session has to take place within a period of 6 months of the previous session. So, Millers, if, for example, a notice is issued and there are disqualification petitions pending, and a notice is issued, Millers, just after the session is over, Millers, for 6 months, Millers, the tribunal cannot act. This is the consequence of Naban Rabia.
That once, according to you,
not according to me.
Right.
Yes.
Once notice is given to the speaker for his removal, then he is disqualified. And so to speak, he has to stay his hands then.
Yeah, he has to, Millers, that means the 10th schedule there must be a hiatus, Millers, in the functioning of the 10th schedule. I mean, this is a position in constitutional law
that is cleared.
Cannot be accepted. Because constitutional authorities can never be in hiatus at any point in time. May it be parliament, may it be government, may it be courts, may it be election commission. No constitutional authority constitutionally pauses at any given point in time in the history of the nation, in the functioning of constitutional democracy. It cannot be. And the consequence of this judgment is, and this is really the basic flaw in the judgment, that the moment a notice is issued, and the notice is issued, Millers, under 179 in the context of the state of the Constitution with respect to his functioning in the assembly. But the consequence of that is that the speaker not just does not function in the assembly, he also is a tribunal. And the consequence of that is that his functioning as a tribunal is state. And this has now become a device to ensure that your disqualification petition is not addressed by the speaker, is not dealt with by the speaker. In the meantime, politics takes over. You topple the government. You, Millers, swear in the chief minister. And then, Millers, what happens is then this is in limbo. This goes on, Millers. And then you have your own speaker, and Millers, history has shown since 1985, speaker after speaker, speaker after speaker. Millers, in the context of how speakers have functioned, Millers, they always support the political party who have anointed them in that position. When it comes to Millers, the opposition, the proceedings are expedited. When it comes to that government, Millers, the proceedings are stayed. Millers, this cannot. That is why I personally feel, and this is only my personal opinion, that the minority in Holohorn was right.
But then, are you asking for reference of Quixote?
Millers, personally, I think that must be.
Then
Two judges held, Millers,
they have held it
that this is unconstitutional. This whole is unconstitutional. Why? Because, Millers, the speaker can never act as an unbiased umpire in the game of politics. And we've seen it happen, Millers, and I'm not saying this, judgment after judgment, whether it is Jagdeep Singh.
The entire 10th schedule depends on speaker.
That's right.
In the center.
That's right. I mean, this is time for us, Millers. It's time for us. It's time for us, Millers, to actually relook both this Naban Rabia as well as the 10th schedule. Because it has created havoc, Millers. Governments fall, because of political machinations, and only because you issue a notice. Then it's a more interesting thing. Then I'll come to the details, Maharaj. Now, I issue a notice to the Speaker. I have no intention of taking it forward. I may have no intention, because a mere notice can be issued by one member of the Legislative Assembly or one member of Parliament, and he stays the functioning of a constitutional authority. The moment a notice is issued, then when the session is held, so if supposing it is issued in between sessions, say 4 months in between, for 4 months nothing will happen. When the session is held, it has to be under 179, 14 days notice has to be given, and under Maharashtra Assembly rules, 7 days notice has to be given. Then, leave is sought from the House whether the individual can actually move that resolution or not. Leave is sought. And if 29 members of the Maharashtra Assembly do not stand up and support it, the notice is dropped. If 29 members approve it, then the resolution is moved. And at the time when the resolution is moved, the Speaker against whom the resolution is moved cannot sit on the chair. That's the only time. He can vote. He can make a speech, but he can not sit on the chair. Somebody else will sit on the chair. So he can't be a judge in his own cause. That's the only time that the Speaker, somebody else becomes the Speaker. So till the resolution is moved, there is no actually motion against the removal of the Speaker.
Yes.
Till the resolution is moved. Here, the 5 judges have said, moment a notice is issued, the Speaker becomes, as a tribunal, becomes dysfunctional.
You are seeking a reference of Nabam Rebia.
Yes,
yes. Can we look at it so that,
yes.
read it, of course, so that we can see how...
Yes, I'm showing you, Lordship, the judgment itself. Volume 2.
Compilation, Volume 2, page 960.
Judgment compilation, Volume 2, page 960. Oh, Volume 1? Okay, sorry.
Volume 1?
1 or 2?
Starts at page 9.
Volume 1.
I'm so glad that we have brought some order to our functioning as a constitution bent by having common volumes and, everybody on the same page.
No, that's right. It's a great
Mr.
step.
Sibal, what are you doing with paper in your hand?
I am learning. Actually, I am learning.
Yeah, come on now.
I have it on my iPad also.
Your junior is there, she will assist you. Use the.
I allow me some hybrid in the meantime.
We're not asking you to sit down in favor of your junior. But we can certainly issue a 142 is very broad, right? So
Yeah. No, actually, I've been doing this for several days now. I should be fine next time I come before your lordships. Let me, before I read Rebia,
anybody who wants another training session from our team, we'll have a training
No,
session.
I would love it.
They are all. Last time they had held it when you
This
did
weekend
when you did
this
the
weekend I
NCD matter.
No.
So
Let me tell you, before you read Rebia, what Rebia was about.
973 PDF.
Page 9.
PDF page 973.
Yes.
Before you read it, let me tell you what Rebia was about. Rebia happened in the context of the Arunachal Assembly, wherein in 2015, sometimes on 15th October 2015, the next session of the Assembly, on the aid and advice of the Council of the Minister, was fixed as 16th of January, 14th of January 2016. Right? In the meantime, as has happened to the Congress party often enough, lots of people were wanting to defect to the other side. So a lot of letters were written to the governor that the Chief Minister Nabam Ruki is not behaving in a proper fashion, that there are a lot of allegations of corruption against him, we don't like him, and these letters were exchanged with the governor. When this was happening, the Congress party met and said, look, this is all illegal activity and you are liable for disqualification. So to cut the story short, sometimes in November, a notice was issued for the disqualification of 21 MLAs of the Congress party. And that notice was fixed for the 16th of December. for their disqualification. When the governor realized that this happened, a notice was issued to the speaker that you cannot decide this issue. So a notice for removal of the speaker was issued. That's how one of the issues came up. The governor, in that context, knowing that these people may be disqualified, preponed.
He preponed the, yeah.
He preponed the session to the 14th of January. December, 14th of December. And on the 9th of December, he sent a message to the House that this is how you will conduct your proceedings. So, two issues arose for consideration. Number one, does the governor have the discretion to prepone the session? Number two, can a governor give a message to the speaker as to how he is to conduct the proceedings in the House? Those are the only two issues.
The main issue.
Right.
When we argued the matter, Justice Mishra said, but you know, there is a notice against the speaker for his disqualification. That question didn't arise in the case, but we would like to decide that. And therefore, four of the judges held that mere notice would result in the hiatus in the functioning of the speaker. And Justice Lokur said, how does this question arise? This question doesn't arise in this case. This is all arbiter.
Let us see the,
Yes,
this is together.
This is what I'm just telling you, this is the lay of the land as far as the judgment is concerned. This then was the order of the Deputy Speaker, struck down by this court. The order of the governor preponing the session, struck down by this court. But more important than that, in the meantime, a new government had formed. Because these 14 members were declared to be continued to be members, they defected, a new government was formed. This time, this court, first time in the history of this court, in fact ensured a status quo ante and said, we will not tolerate this. Nabam Tuki became the chief minister for 2 days. And then somebody else, Khaliko Pul, he then defected and then he became chief minister. The point is, why did we have the 10th schedule? We had the 10th schedule to serve the cause of political morality and to ensure defections don't take place. And now this very 10th schedule is actually subverting that. There was a time when 356 was misused, and by all governments. Today, the 10th schedule is misused by all governments. That's where we are. So you have to decide, whether you want to uphold Kyoto or a whole new system has to be put in place if you want to really serve the cause. Now, there's another shenanigan happening. When you defect, we know that they are defecting. So all of them go to the speaker and resign so that they should not be disqualified. Now, because they resign, then elections to take place. Then they win, then they become ministers. That's another thing, Your Lordship, my Lordship, the Chief Justice has seen that happening. In Karnataka, saw that happening in Madhya Pradesh. This is the new thing that's happening. So how is this going to work? And how does a notice to a speaker deny him? And look at it another way. There may be several disqualification petitions pending against several members of several political parties. You may have a disqualification petition against a Samajwadi Party, a BSP person, a Congress person. So a Congress member, one MLA files a notice, he can't even decide the others. He can't deal with the Samajwadi Party or he can't deal with the BSP because he's disqualified.
Let us see those observations in this judgment.
I'm sorry?
Let us see those observations.
Yes.
Like the resolution was passed and the resolution was to be considered for the disqualification of a certain speaker.
No.
See,
in this case, a notice was issued.
No, resolution was also, and it was directed.
Just hear me. A notice was issued, and on the basis of that notice, on the 27th, a writ petition was filed, 468 and 469. On the basis of that, it was stated that now that a notice has been issued, the speaker can't deal with the matter. True, it was later, Madam, the resolution was passed. So, Madam, on that basis, and the other thing that happened, two things happened. One, they said that you can't deal with the matter. Two, Madam, the speaker had given only 2 days notice to the MLAs. Second ground raised was that this 2 days is not enough. So these are the two issues raised in writ petition 468 and 469. And on that basis, on the 27th of June, this court